Hi, I'm Beth Walensky, Legal Practice Professor at the University of Michigan Law School. This video is about rules, the rules part of the CREAC analysis. Now, coming up with the rules, learning how to synthesize them and draft them, is at the heart of legal analysis. The good news is that once you have done that for a particular question you're trying to answer, you will have done the hardest part and the most significant part of putting together your analysis. This is the second video in a series of 4 videos on CREAC, and it is important that you watch them in order so you can see how the pieces fit together. So, first of all, what is a rule? For our purposes, you should think of a rule as a statement about how courts analyze an element or a factor or some other legal question. Now, there is a much more formal definition of a legal rule. We're using this definition to help us figure out what information goes into the R part of CREAC. So let's look at what the 6 major categories of rules are. You should think of rules as falling generally into one of these categories. A rule is a statement of something that makes an element more likely to be satisfied or less likely to be satisfied. It could be a statement of something that is necessary to satisfy an element or is not necessary to satisfy an element. It could be something that is sufficient to satisfy an element or not sufficient to satisfy an element. And remember from the first video that while in Julia Livingston's self-defense case, we're concerned with the elements of self-defense, frequently you're actually analyzing factors of a balancing test or something else. So you could substitute the word factor for element in all 6 of these. This is not an exhaustive list, but it's a great place to start when you're first thinking about how to draft and state rules in a clear, precise way. So what do I mean by drafting and stating rules in a clear and precise way? I mean that when you write a rule, you want to make sure you are actually using the 6 categories to explain how the information you have identified as important to a court's decision actually affects the court's decision. So here's what that means. When you're reading a case, you may find something that looks like it was relevant to a court's decision or to multiple courts' decisions. And you might be inclined to write something like this. One thing courts consider is whether XYZ is present, where XYZ is some fact or set of facts. That might be a helpful place for you to start in your thinking. However, when you actually want to put the rule together, you need to be more precise. Your reader needs to know not just that courts consider XYZ, but what role XYZ plays in whether the element is satisfied. And that's where those 6 categories come into play. So for example, maybe what you want to say is where XYZ is present, the element is satisfied. That would be a statement that XYZ is sufficient to satisfy the element. Or maybe this element is only satisfied if XYZ is present. That's a statement of something that is necessary to satisfy the element. Or maybe what you really need me to say is if XYZ is present, a court is less likely to find this element satisfied. That's just 3 examples from that category of 6. Now, let's look at some specific examples. This video is going to go through and show you rules from 3 of the elements in a self-defense claim. We're going to start with imminence, and then we'll look at great bodily harm, and finally, reasonable belief of harm. If you were actually writing this in a memo, you probably would want to do an entire CREAC analysis for one element before you moved on to the next one. But we're going to focus just on rules for each of the elements in this video. So remember from the first video that we came up with a rule for what makes something imminent, what makes the harm the defendant feared imminent. And this is the rule we had. An action is imminent even where it is merely close rather than touching, or at least near at hand. So this is a pretty easy rule. Why do I call it an easy rule? Well, for 2 reasons. One, I really need just this one sentence, at least as a start, to explain what imminence is. The other reason it's an easy rule is because I found this directly in a case. The Michigan Supreme Court case, State versus Juneau, actually says that an action is imminent even where it is merely close rather than touching, or at least near at hand. If I thought it was helpful, and I think it might be here, I might add one more sentence to make the rule a little more specific. Now, even with a pretty straightforward rule like this, it's often helpful to think about whether I can make the rule more specific for my reader. For example, here I might add a second sentence into the rule, something like this. Where the victim has a weapon within arm's reach, the harm is imminent. How do I know that that's part of the rule? It's really the only logical conclusion to draw from the fact that in this case, Juno, the victim actually had a weapon, his gun, within arm's reach. Remember, it was strapped to his leg. And there, the court held the harm was imminent. So I can easily take that somewhat general rule that talks about the action being close rather than touching, or at least near at hand, and make it more specific. One more thing before we move on to the great bodily harm element. Remember, we had those 6 major categories of rules. We can categorize this one as being about something that is sufficient to satisfy the element. Where the victim has a weapon within arm's reach, the harm is imminent. That means that this is one way to show the element is satisfied, but it's not the only way. There may be other kinds of things that a victim could be about to do that would be imminent. For example, if the victim already had a weapon in his or her hand, certainly the harm would be imminent then as well. So for the great bodily harm element, I can pretty easily come up with one rule directly from the case law. Great bodily harm includes injuries that could cause permanent disability or disfigurement, because one of the cases says that and describes those as injuries that satisfy the element. But I need more here. Why? Well, for one thing, our client, Julia Livingston, didn't actually suffer any injuries. Her defensive action prevented or possibly prevented her from suffering an injury. So I need to figure out whether there's more that I can do from the case law to talk about what kinds of harm she feared she was going to suffer. This is where I need to read the cases closely. And if I do that, I can probably figure out something a little more specific that'll help me figure out what's going to happen with Julia Livingston's claim for great bodily harm. And here's the rule I come up with when I read the cases. The defendant can satisfy this element even where the victim didn't have a traditional weapon. Hard, everyday objects used as projectiles or bludgeoning devices can inflict great bodily harm. Now, how do I know this? I engage in a kind of reasoning called inductive reasoning. I've read the cases. I can surmise that if, for example, the victim is holding a gun or a knife, that almost certainly would constitute a fear of great bodily harm. Conversely, if the victim is holding merely a pillow, that almost certainly would not satisfy the great bodily harm element, at least if I was worried only that the victim was going to throw the pillow at me. But that leaves a whole lot of stuff in the middle. I have one case where a court said that throwing a folding chair at someone is something that would satisfy the great bodily harm element. I have another case where the court said that throwing a frying pan at somebody would satisfy the great bodily harm element. I can reason backwards from that to a more general rule that hard, everyday objects used as projectiles or bludgeoning devices can inflict great bodily harm. That's an informative rule for Julia Livingston's situation. Why? Because there's a vase sitting outside the door that her roommate just walked through, and she's worried that her roommate's going to pick up that 10-inch vase and throw it at her. This rule helps me figure out whether the great bodily harm element is satisfied in her situation. Now, this kind of reasoning and similar kinds of reasoning are essential to the legal analysis process. If all you're doing is reading cases for what courts actually say, that's that first rule, then you're not doing enough work here. That's an important enough point that I'm going to say it again. If all you're doing is looking for what courts actually say they're considering, then you haven't done the job right. You haven't done the actual synthesis and engaged in the underlying legal analysis that attorneys engage in all the time. So let's quickly categorize these rules for great bodily harm. That first one, great bodily harm includes injuries that could cause permanent disability or disfigurement. That is something that is sufficient to satisfy the element. That second rule actually has 2 separate sentences. The first one, the defendant can satisfy this element even where the victim didn't have a traditional weapon. That's something that is not necessary to satisfy the element. It is not necessary that the victim have a traditional weapon in order for the defendant to have feared great bodily harm. And that last sentence, that hard everyday objects used as projectiles or bludgeoning devices can inflict great bodily harm, that again is something that is sufficient to satisfy the element. So now let's look at the reasonable belief of harm element. This one is the most complicated. There's a lot going on here. The cases suggest there are a lot of different things that may be relevant to a court's decision. So we need to figure out what those things are and what role they play in a court's determination of whether the defendant reasonably believed that the victim was going to cause her harm. How do I do that? Again, I go back to the cases and I read them closely and carefully. Even if I've already read them once or twice, I probably want to read them again, looking specifically for helpful information about how courts determine whether this element is satisfied. So let's start with Juneau, our Michigan Supreme Court case. I can pretty quickly find a clear rule that the court states directly. When I read Juneau, the Michigan Supreme Court decision, I can pretty quickly and easily find one rule that the court states directly. When the court says, when considering whether there was a reasonable belief of harm, the court considers whether a reasonable person would have believed Mr. Miles posed a threat of harm. This is called the reasonable person standard. You're going to spend a lot of time in law school in different classes talking about the reasonable person standard. What it means here is that it's not enough for our client, Julia Livingston, to show that she actually believed that her roommate was going to cause her harm. She also has to show that a reasonable person in her situation would have believed her roommate was going to cause her harm. So the first helpful piece of information I get from my rules section from State versus Juneau is that courts use a reasonable person standard. I'm going to write that down in my notes. And I could, if I had a more precise sense of of how courts use it, I might actually put that down now. I might also just want to brainstorm everything I find and then wait and go back to figure out what rule statement I want to actually write for each of these things. Now let's look at the case again, because that's the easy rule that I get from the case. Again, the one that the court seems to state pretty directly. But there's a lot of other helpful information that I can glean if I read the facts closely for what kinds of things seem to be driving the court's analysis and the court's ultimate conclusion as to whether this element is satisfied. For example, one paragraph down on the same page, I see that the court mentions and seems to focus on the fact that the victim displayed a weapon to the defendant. Remember, the victim in this case, Mr. Miles, lifted his pants leg to show the defendant that he had a gun strapped to his leg. That seems to be something that's relevant to the court's analysis. I might at this point have a sense of which of my 6 rules categories it falls into. And if so, maybe I would write down that displaying a weapon, or where the victim displays a weapon, that makes it more likely that the court will find this element is satisfied. I might not have done that amount of thinking about it yet, but just by writing displaying weapon in my notes, I have told myself that I need to go back and figure out which category that one's going to go into. Finally, the court also says that mere threats are insufficient, but suggests that where you have threats combined with some sort of physical aggression, that might be enough to satisfy the element. Again, I might not have figured out at this point or done the analysis to figure out what role this set of facts plays precisely, so I'm just going to write that mere threats are not enough. That does fall into one category, that's an insufficient way to satisfy the element. But that threats plus physical aggression are probably enough. When I go back and look at it more closely, after I've finished kind of brainstorming and reading through all the cases, I should be able to state more specifically whether threats plus physical aggression are definitely enough, in other words, that they are sufficient to satisfy the element, or that they make it more likely that the element is satisfied, or perhaps that they are necessary to satisfy the element. So I'll have to figure out which category that information falls into. So let's imagine now that I've gone through all the cases and pulled out all of the information that I think is potentially relevant to draft the rules. At this point, I encourage you to pause the video and to go back and reread the cases and look for other kinds of information that seems to be important to the court's decision, to see if you can come up with potential rules that you would use to analyze this element. these are the rules that I came up with when I went back and I read all 4 cases very closely. Now, your list, if you came up with some rules, is almost certainly different from mine, and that is fine. What I encourage you to do now is to pause the video again and spend some time reading through these rules that I came up with. This is still a brainstormed list. In other words, I have taken the information and put the information into clear rule statements, but I still haven't figured out what the relationship is between each of these rules. And that's the important next step. But before we do that, go ahead and read through this list to see if you can figure out where in the cases I found the information that suggests this stuff is stuff that courts consider when analyzing this element. So now I'm ready to think about the relationship between all of these pieces. For the purposes of this video, I have reduced each of the rules to a quick phrase to help me sort of move things around so there's not too much text on the page. You don't have to do that step. You can probably, just with a list of rules, spend some time playing around with them. So here's what I'm going to do. I always want to start with the most general point and move to the more specific ones. The most general point I think I have here is that the reasonable person standard is the one that courts use when determining whether the element is satisfied. It happens to be the case that I already have that one at the top in the first sort of position, so I'm going to leave it there. If when I'd come up with my rules, I found this one later and it had started out down here somewhere, I would organize it by putting it up at the top because I think that's probably the most general statement that I have about how courts analyze this element. It kind of sets a framework for the entire analysis. Now I can also look for other things that seem more specific or more general. Another thing I can do is look for rules that I can categorize together because they seem to go together or because they seem to all be on a similar point. So for example, I have this rule that the defendant doesn't have to be right about what the victim was going to do, as long as the defendant was reasonable in her belief. I also have this rule that the defendant doesn't have to be certain. If the defendant thinks there's a good likelihood that the victim's going to harm her, she doesn't have to say she absolutely knew it. Those 2 rules seem to go together because they're 2 different ways of talking about the defendant's belief. So I think I'm probably going to categorize them together in my overall analysis of this element. Some other things I can do when I categorize my rules is see that I have a number of things that make it more likely that the element is satisfied. Things that are probably not enough on their own, but that help get the defendant to the point where she can convince a court that her fear of harm was reasonable. So the victim's display of a weapon is one of those things. If the defendant knew that the victim had a history of aggression in similar circumstances, that's something that makes it more likely the defendant's belief was reasonable. If the victim pursues the defendant after the defendant tries to escape, that makes it more likely that the defendant's belief that the victim intended to harm her is reasonable. Another thing that the court cases suggest is that where the victim is intoxicated, that makes it more reasonable or more likely that the court will find the defendant's fear of harm was reasonable. My next step will be in organizing them in a logical way. Usually, again, starting with the most general rule and getting more specific, and then thinking about what logically makes sense, what kinds of things ought to come first in the discussion in order for the later rules to sort of fall into place. So after I've spent some time thinking through the organization of my rules, this is what I came up with. This would be another good place to pause the video to read through how I've organized the pieces of the analysis. Now, one other thing that I often do at this point, and you can also do this earlier in the process of figuring out the rules and putting them together, is to review my list to make sure that every rule on my list is informative for my client situation. What do I mean by that? Well, the rule about verbal threats, for example, says that verbal threats are not enough on their own to lead to a reasonable belief of harm. That rule doesn't seem so relevant to Julia Livingston's situation. Why? Well, her roommate didn't utter any verbal threats. She didn't threaten to hurt her or to throw the vase at her. So it's probably not all that informative to tell that rule to my reader. On a different set of facts, that might be a very important rule to include. But I only want to include those pieces of information, those rules that are going to help my reader understand what a court's going to do in this situation with our current client. Let's briefly review a process you might want to go through when you're trying to figure out what the rules are for a particular element or factor. First, you want to read the cases closely, looking for explicit statements of rules, but much more than that, significant facts that help suggest other things that matter to the courts when they're trying to decide whether an element or factor is satisfied. Once you have that list of things that courts consider, rewrite each of those things using the 6 categories. Again, that's a key analytical step, and it'll probably require you to go back and look at the cases again to figure out what role each of those things that you've identified as important play in the court's decision-making. Get rid of any rules that turn out to be not informative for your client's situation. And then organize the rules you have left. Start with the most general statements that help frame the overall element and move towards more specific rules. Figure out which rules are related and group them together in a helpful way. So I know this seems like a lot of information. Drafting rules can be complicated. I have 2 pieces of good news about that, though. The first is that figuring out what the rules are, in other words, figuring out what matters to courts when they make their decisions, is something you're going to be doing in pretty much all of your law classes all year long, and frankly, for the next couple of years as well. So you're going to get lots of practice in figuring out what things matter to courts. The second piece of good news is that the other videos in the series on explanation and application and counteranalysis cover steps of CREAC that are easier to figure out and to write. So we're going to move on to those now.